right, so we've got a number of matters before the court today, and it's fairly clear that the parties did not heed this court's encouragement to stand down, quit all the nonsense, quit the fighting, quit the harassment, quit the videoing, and just try and be decent neighbors. I guess I was overly optimistic that you guys could be decent people. And I'm talking to both sides. This is no way to engage with each other. If you are really looking for years worth of litigation, it's absolutely sad that you're putting yourselves in that position, that you're choosing to be miserable. You're choosing to fight over everything. You know, the court has to take up whatever stuff that you file. It's an inordinate amount of filings. It's an inordinate amount of back and forth, bickering, he said, she said. Not a great use of this court's time and resources to deal with the parties here when there's no reason for the continued animosity back and forth. The one legitimate thing that is before the court, I described easement, and it seems like it boils down to the west half, and it should be the west quarter. That's what Ms. Rowan is requesting, and it sounds like, Mr. Dyer, that you agree that the court messed that up and it should be the west quarter.
Yes.
Okay. Rest of the filings deal with motion for protective order regarding some discovery things. Now check, seems to me that discovery had already closed on this case. Is that right?
Pull up that scheduling order on that. Wasn't able to view on the computer earlier, but let me take a look. It should have been, discovery should have been completed a while ago at the pre-trial. Scheduling order was issued July 26th of 2024 with 150 days of discovery. So discovery should have closed December 23rd of last year.
Means, Mr. Dyer, is that once the discovery closes, that's the end of the fact gathering part of the case in terms of being able to make requests for certain proof to support and claim that you have. Different posture if the request was made while discovery was still open and there was no the opposing party didn't respond. Typically, the way that would come to the court would be on a motion to compel discovery. So,
I'm asking for things specifically that took place after your judgment, Your Honor. On April 17th of this year, she created a Facebook. In that group, she talked specifically about me and Dawn, about this court case.
right, I've read that. But that's all new stuff that could be new causes of action. Okay, so when you file a complaint, you say this is what my grievances are up until the date that I filed this. So otherwise, there would be no end to ever. It would just be a constant, more allegations, more answers. So whatever happened after that is not part of this case.
Okay, so that would be covered in my amended counter complaint then that I have filed. Your Honor, the day we left court, they started blocking and restricting the easement again. Every time we go down it, we're getting yells, taunts. She's being called a whore, a baby killer. This has gone on since the day after court, Your Honor.
If that's true, that's not part of this case. It could be, if you're doing things that are in violation of my opinion and order, that's one thing. That's subject to potential contempt. If it's new bad actions or activities that aren't originally complained of, that would be a new case, because we just can't keep amending Because then the case gets no finality.
That I understand, Your Honor. And if they would have ever ceased, we wouldn't be amending. If when we walked out of court on March 31st, they had not started doing this again on April 1st, we would have no need to amend our case. That's why I asked Your Honor for sanctions in the motion for her, I'm sorry, Your Honor, for her motion for clarification, because she specifically stated in this court that the easement was for the two properties behind her. And then as soon as we left court, she changed it to the easement was only for the one property behind her.
I don't care because I already issued an opinion on the easement.
But that was
that part, the easement part of the case is done.
I understand that, Your Honor, but that was her reason for reconsideration. And that is why I asked for sanctions. I've spent hundreds of hours trying to reply to this. And it's all frivolous. And she knows it.
Reconsideration, I fixed the language. That's legitimate. I mean, I messed up the legal description for the one, and it had to be fixed. Absolutely.
But she was also stating that you made a palatable error, which
I'm denying.
But that's what my reply to that cost money, my effort, my time, and that was a frivolous motion.
It wasn't frivolous because part of it needed to be changed.
I think the reason why he thinks that it was frivolous is the fact that she wants reconsideration. My understanding and why we have the rights to use both the right of way and the easement, and she wants clarification on that also.
And I think the reason she wants clarification on the 50-foot easement is I found them up off their property by my house measuring the 50-foot right of way. Not their property. Your Honor, I am begging the court to stop this. Yes, my actions have not been perfect and I have overreacted, but this has been a daily occurrence since we left court. And if nothing else, can you do a show cause hearing to find out why they have continued to not follow your orders?
Before the court, and you could put the allegations in writing, the court will determine whether it needs to be a show cause.
I will do that.
First of all, I've not stepped 1 foot beyond my property line, except in 2019, when I went to introduce myself to Mr. Dyer and ask him to not plow gravel and dirt. I've not left my property.
Well, let me just stop you there. I understand that your position, and unfortunately for everybody, I still have to have a trial on all this harassment stuff. So I'm not here to decide that today. Now, the statements that you're making about not sitting off your foot on not leaving the property, that sort of thing, that may be very relevant if Mr. Dyer puts together a motion for contempt for violating my court order, and if I determine that there's enough information there to warrant a hearing on that, we'll have a hearing, and then whether you did or didn't do what he raises in that pleading would become. But right now, I'm not here to decide all these issues that were subject to the harassment.
Second, they filed papers last week and had them sent overnight priority mail to me for me to pay for their costs for that priority mail. Friday, they attempted to deliver the post office.
So that, like postage due, is that what you're talking about?
Correct, yes. $30-some postage due for me to pay for their filings.
No, Your Honor. No, we paid for that.
Well, again,
We have the receipt.
next stop. I mean, it's funny. It's one of those things where one side says black, the other one says white. And at some point, there is some objective truth. So if you're saying that you paid for the overnight mailing, and you paid the right amount for it, Like if you went to the post office and they weighed it up and they charged the right amount and you paid for it, there would be no reason for them to ask them for payment. So I don't know, but you clearly understand, both parties understand that when you send something to the other party, the cost of doing so is your own responsibility. Right?
Yes, sir.
Okay, perfect.
I actually have the receipt in my car of proof of that we sent it and we paid for it from this.
How much did you pay for?
We paid $30-some for it.
$31.40.
And I have the receipt in my car at
Why
this
do
moment.
you think that they post up
When the
$30?
postman came to the door and said, I have a $31 and some odd cent priority overnight mail for you. And I asked him 3 different times for me to pay for. And he said, yes, you need to pay for this. And I said, I can't pay for this mailing. So you're refusing to pay for it? You're refusing the mailing? And I said, yes, I'm refusing. I can't pay for this. I don't have the money.
It's in my car.
She can go get it. Your Honor, can I approach the court? I would like to show.
What do you?
I would have taken it if it actually, if the mailing.
These right here are discovery answers, many of which you have already ruled on. These answers are notarized. These 2 pages, one from her and one from him, are full of lies that you've already decided on. I want the court to see that they are not above lying.
It's not where we're here today. It's not where, when you have a trial, all that stuff will come out, and that will probably, the day that we have this trial will probably be the worst day that I ever spent in court hearing a case. Because it'll be accusations back and forth. It'll be almost impossible for me to determine when, what, where, why, how all these things happen. It'll be nothing but bickering and just all the stuff that, so it will probably be the worst trial that I ever have to sit through. But I have to sit through it, and I will. The credibility of the witnesses and the proof of all these things, that comes at this trial that I am loath to even schedule.
I really wish it was a trial you didn't have to hear your answer. I really do. Unfortunately, this is my 6 years of my life. I can't come or go from my home without this.
And the worst part about it is, I think even after trial, it's not going to change who you are and the way you do business, and it's not going to change who they are and how they conduct themselves. It's not going to change a thing. It may even make things worse. But that's what you guys have brought to court for me to do, and that's what I'll decide. Because it's clear that both parties just want to fight.
Your Honor, I would prefer to just not. I really would. But I can't leave my house without screams and taunts coming from these people. I can't leave my house without driving by the easement. We have not used the easement in over a month that you told us we could because of the things that happen when we do.
Here's to be paid in full. So I
I'm
don't know-
sorry.
I don't know who's told you what, but they paid you.
The postal delivery man stated that it was a $31-some charge that I needed to come up with. He stood, I asked him 3
If that was the case,
times.
all he would have said was just sign for it.
I asked him 3 times. He knocked on my door. If it didn't need to be signed for, he would have left it in the mailbox.
Original complaint was that they sent it to you with postage due. They did, they paid for it. So there you go. Problem solved. Typically, I would send parties to mediation, but I don't think that's gonna work with you guys. So we're just gonna have a trial. And we'll go from there. So is a day enough? 2 days? How much time of the court's time are you gonna waste with this trial?
Everything that I'm going to present to this court will be shown with proof, date, times, and witnesses.
So how much time?
A day.
So we'll send out a notice for a 2-day trial.
Your Honor, we have a motion in front of you on October 14th. And that is for the amended counterclaim that we have filed because of the things that have happened since court.
So I'll move on it then, but I'm just telling you right now, I'm not, I doubt I'm gonna allow that because nobody can hit a moving target. So at some point, things close. These are the allegations that we're dealing with because the way you guys go, and I'm saying you guys, I'm saying both you guys, the way you guys go, every day, every week, there could be more allegations raised and more things, and no. So we're just dealing with what was originally pled. That's it.
So in other words, Your Honor, they can continue to do what they're doing. She can go home and put more people into her Facebook group where she accuses me of going after her 12-year-old daughter, where she lies directly about what's going on in this courtroom, which has 300 people in it now.
Well, the fact that you phrased that question in that way means that what I'm telling you, you're not even understanding. I'm saying it's not part of this case. I'm not saying she can or can't do anything. It's not part of what's been filed so far.
And that's
I
why
can't
I
give
asked
you more
for the amended
information.
counterclaim, Your Honor.
No, we're dealing with what was originally pled. Either you can prove your stuff and they can prove theirs or not. What was originally pled. That's it.
So I need to file a new claim about what's happened since.
That would be the way to bring it before the court. It's a whole new case. And again, you're making my point that there's no end to this.
Your Honor, we haven't done the ones continuing it. I didn't block the easement as you instructed us not to.
So we'll see. We'll see. That's what the trial's about. So it'll be a 2-day trial. That's all for today.